Hi, everybody. My name is Karen Tereposky. I am an associate in the senior associate in the office of Senator Tremarkin in Calgary, Alberta, and I practice in the area of employment law with some human rights aspects to that as well. And I'm here today to answer any questions you might have about employment law or human rights or anything like that. And hopefully we get some interesting questions today. We usually do. So looking forward to seeing what kinds of issues everyone out there has to discuss. So nothing up yet in my little chat area. So I'll just wait for that to start buzzing. While we're waiting, we can kind of think about some of the things that have been happening in the news as usual. There's a lot of major layoffs going on. As always, there's Toys R Us is closing a bunch of stores and laying off a bunch of people, and Verizon is doing a massive round of layoffs. Some of the questions that have come up in relation to those companies are whether employees are entitled to severance when a store is being closed or when a company is shutting down a massive part of their operations, and the answer is yes. Just because the company is shutting down a store doesn't mean you don't get severance. You're still losing your job. So that is it's an important thing to consider. That severance should be a full severance too, not just what you're entitled to under employment standards, which reportedly a lot of the offers have been just those employment standards minimum. So if you're subject to a layoff like that, reach out and we can discuss that with you. We do have a question that's just come in from Reddit, so we'll deal with that. It's from Mark. He says, I was laid off last week after 2.5 years with a mid-sized tech company. My termination letter says I'll get 2 weeks pay in lieu of notice, but no mention of benefits continuation or vacation payout. My employment contract doesn't specify termination terms beyond what is required by law. I've heard I might be entitled to more under the common law. How do I know if that's true and whether I should sign the release that they gave me? Okay, well, there's a lot to kind of unpack there. First of all, if you were employed for 2.5 years, you are entitled to 2 weeks pay in lieu of notice under the Employment Standards Code. The company cannot ask you to sign a release. They have to pay that. You do not have to sign a release to get that. That is required by statute. So you should not be being asked to sign a release, nor should you sign one, because there's nothing that you're being offered there that you are not already entitled to under the Employment Standards Code. So that's the first piece that jumps out to me there. You've mentioned there's no mention of benefits continuation. In Alberta, under our employment standards, there is no requirement for employers to continue benefits through the statutory notice period. So often when employees are terminated without cause in Alberta or for cause, either way, the benefits cease on the day of termination. Usually what will happen is there'll be some language in the termination letter that tells you how you can convert those benefits if you choose to do that. But it isn't illegal not to extend benefits in Alberta. Vacation payout you are entitled to under employment standards, and that should be something that you're getting, whatever vacation that you've earned this year, less what you've used. So whatever accrued but unused vacation you have should be getting paid to you. Now, required by law includes common law, pay in lieu of notice or severance. And the 2 weeks that you're being offered is just the statutory minimum or the Employment Standards Code minimum. So common law is going to be more than that. A lot of people kind of look at a benchmark number is about 1 month per year of service, and that depends on a lot of things. What the courts look at is age, years of service, availability of similar employment, level of position, education, etc. Sorry, my computer just shut down for a second there. We're good though. So yes, under the common law, there you are likely entitled to more notice. I would say do not sign that release. I don't think that they are even entitled to be asking you for a release when they're only giving you 2 weeks, because that is your entitlement under employment standards. For an employee between 2 and 4 years, you're entitled to 2 weeks. you do not need to sign a release to get that. If they're offering you something over and above that, then they can ask you to sign a release, but not for just 2 weeks. That's already a minimum under the legislation. So yes, you should be entitled to more. No, you shouldn't sign the release. You can look to see what you would be entitled to potentially under the common law for a full severance by going on our website and using our Pocket Employment Lawyer severance calculator. That'll tell you kind of what you might expect in your situation. It'll ask you for a bunch of your information, and that's going to tell you how much you could potentially be entitled to. And then reach out to us and we can help you get it. So quite a bit to unpack in that question. Hopefully that helps you, Mark. Next question, looks like it's from YouTube. I got laid off after working for a company for 8 years, only offered 12 weeks of severance. Is this enough? So not likely. That seems very light for an 8-year employee, but the amount of severance that is appropriate depends on a few factors. Like I said, age, years of service, level of position, availability of similar employment. So, what you should do again is check out that Pocket Employment Lawyer. That'll tell you kind of what, you could be entitled to. And I would think it's going to be more than 12 weeks. That's not a lot. Another question from Facebook from Nini. I'm 19 years old and I just found out that I'm pregnant. My boss did everything to push me to resign: verbal harassment, judgment, reduction of hours, etc. What other recourse am I entitled to? I'm a hairdresser, if that matters. Well, that is a human rights violation. So you cannot be forced to resign. Resignation has to be voluntary and unequivocal. So you don't need to resign. If you're being harassed and it is connected to your pregnancy, then your human rights are being violated on the basis of gender. And there's potential liability for your employer under the Human Rights Act. You can be entitled to just general damages for the discrimination on its own, as well as to any wage loss. So if you're put in a position where you basically have to quit because your job has become so toxic, you could potentially claim any wages associated with the discrimination based on your pregnancy. Reach out to us. We can discuss that and see, what we can do for you. There's some online resources as well. You could, look on the Human Rights website and read up on that. Hopefully that helps. Another question from YouTube. This is from Bill. Please excuse me if I'm naive, but I have a lower level job and this is new to me. I was contacted by a research company who wants to pay me to ask me questions about my work. I don't want to ask my boss because I assume he'll take the easy route and just tell me no. I also don't plan to talk about anything concerning my company, but that's a fine line if I'm to talk about what I know because it all comes from my job. Is this a safe thing for me to do? I'm not going to lie, this sounds a little bit suspect. As my kids would say, it sounds kind of sus to me. This research company asking you about your job and paying you for it. It does sound like potentially they are trying to fish for personal information, which can be a way that individuals steal identity. So I would do a lot of research into whether this research company is legitimate. It does sound kind of suspect. And as far as asking your boss if you can give up this information, anything confidential, you should not be giving up at all. Any trade secrets, any of your company's information, you should not be giving up. That could lead to liability on your part. So I do have some concerns about this. It doesn't sound very above board to me. So I would be very careful. Okay, another question from Sam on YouTube. My employment contract includes a non-compete that lasts for 18 months and covers all of Alberta. I'm being offered a new job in the same industry, but in a different city. What should I do? Okay, so the first thing you need to probably understand is the difference between a non-compete and a non-solicit. Most non-competes are actually not usually enforceable because they are usually held to be not reasonable. But a non-compete tells you that you can't work in this industry at all. And normally that's not considered reasonable. A non-solicit is different. It says that you can't solicit the clients of your past employer or employees. Those usually are enforceable. So an 18 months that covers all of Alberta and doesn't allow you to compete sounds like a tough one for an employer to enforce if it really is a non-compete. It would have to be reasonable to protect the employer's business interests. So I look at that and I think that's a hard thing for an employer to enforce against you. What I do tell people though, when we're talking about these non-competes and non-solicits, is at the end of the day, the issue is, are they going to come after you? Because if you take this new job and the employer sends a cease and desist to you and to your new employer, you may lose that job. So it's probably worthwhile trying to navigate this with some legal advice. What we have often done and what I've done on several occasions is I can get a exemption letter for a certain job from the prior employer, and it'll say, we are not going to try to enforce the terms of our non-compete or non-solicit in relation to this new position. And that allows you to become employed without the fear of them suing you or, reaching out to your new employer and saying, hey, this person has a non-compete. Also, when you are taking this new job, you do need to disclose that you have this non-compete. If you don't disclose this to a new employer who's offering you work, that can be, considered to be, withholding information, and you could be terminated for cause for not telling them that you have the non-compete. Because if you are breaching it, if it is enforceable, and if you are breaching it, and your former employer comes after you, they're also going to come after the new company for any profits that arose from the violation of this non-compete. I'd be real careful with it. I would get it looked at by a lawyer, and potentially you can get an exemption, and then you're safe. So be careful with those. A lot of times they're not enforceable, but I would be interested to actually see what it says, whether it really is a non-compete or whether it's a non-solicit, and those have different considerations. So hopefully that helps you, Sam. Next question. Ooh, this is a long one from Bill on Facebook. My spouse worked as a caregiver for a family for 7 years, and she had gotten sick after being injured at an event that she was helping with for her employer. She was a live-out family caregiver. She went on sick leave for a couple months and provided all the medical documentation. Her employer did not provide her with her record of employment. During the last 6 months before her leave, she experienced terrible treatment from her employer, and even during the course of the time she was off in August and September, she was harassed with text messages, called a liar. Dave bombarded my sister-in-law with phone calls, had members of his family calling her. She's 53 years old. He did not provide her the record of employment, so she could not obtain sick benefits through EI. She advised them that she's not quitting. And in the meantime, if he needed to bring in someone else to do the job while she was away, that's his right to do so. I've been supporting our family. She's been taking care of herself. He recently sent her a text message telling her that he's sending her the ROE as he presumes that she has quit. She needs representation to obtain her severance package, that she has been wrongfully terminated, and he has forwarded that she has quit to the government. Can she reach out to you and speak to you? Yes. I mean, that was a lot to get to that point, but yeah, of course, it does sound like there's definitely some issues there. There sounds to be some human rights violations potentially. Also, if you're on a sick leave in Alberta and you've submitted a doctor's note to your employer saying that you're under a sick leave, then you're job protected. 16 weeks of sick leave per calendar year in Alberta, unpaid, but they have to give you your job back and they can't fire you during that time. So that's a violation of the Employment Standards Code. And yeah, I mean, it sounds like there should be some severance payable here. They can't tell you you've quit, especially when you're on a medical leave. I've had this situation before where employers have tried this, and there's an entitlement to severance there. So yes, I would definitely reach out. There's our website at the bottom there, and you can reach out to our intake team if you want to talk to me specifically. You just let them know, and they'll direct that to me. Okay, another question from YouTube. Hello, my boss keeps making inappropriate comments towards me and my other coworkers. The majority of us are teenagers and work at a grocery store, but we don't know what to do. It's making us uncomfy. Okay, so usually if it's a grocery store, it's probably a chain store. There should be some sort of process for you to raise these concerns. Usually with larger companies, there's a phone number or something that you can call to make a complaint or make a report about this. If that doesn't exist, you should be able to go to human resources or whatever they're called in your company and tell them about this. This is something that should be dealt with by the employer before it gets to a point where they have liability, and the employer is actually obligated to investigate it under occupational health and safety legislation. So raise it either, like I said, if there's a phone number that you can call to make an anonymous complaint, or go to human resources. If this is your boss, obviously you can't go to your boss, which would normally be the first person you would go to, your immediate supervisor, but you do need to raise it with somebody. What I would also recommend is to keep records of these inappropriate comments: the date, the time, the place, what was said, who was there. If there's more than one person who's witnessed it, write down those names. That's really good evidence for later on if you have to, if you have to go back and say what happened. It's a lot better than saying, yeah, there was an inappropriate comment sometime last month and I can't remember when or where or exactly what was said. So keep those notes right away. That day, try to write it down. Like I said, note who was there. And if more than one of you are present and more than one of you can keep the notes, that's even better. So document, go to your HR or whatever the process is in your company to deal with this. If that doesn't work, you may need to seek some legal advice or talk to somebody about it. But hopefully that can be dealt with internally and document everything. So hopefully that helps you. Okay, there's another one. I was supposed to start a new position this month, but the employer changed my location after I accepted to somewhere 80 kilometers away. I feel like it's a bait and switch, and now I may be out of a job. Okay, so I guess what we need to look at is whether when you accepted the position, it did say where the position was supposed to be and whether, that was a subsequent unilateral change. If it didn't say, and I have had situations where people don't actually have that in writing where it was supposed to be, and it's left open in the offer, and then the employer puts in a different location. So hopefully in your offer that you accepted, it did say the location that you were supposed to work at, and then they did switch. If they have unilaterally changed that term, that can be considered a constructive dismissal. So as you're saying, you may be out of a job. If you can't do that 80 kilometers away, yeah, you might have to resign, but you should be resigning on the basis of a constructive dismissal. Constructive dismissal occurs when the employer unilaterally changes a material term of the employment contract, and it entitles you to severance. So if you are going to resign, like I said, make sure you say, I'm basing it on a constructive dismissal. You should reach out to us and we can talk you through that process. Sometimes employees like to have us help word the email that you're going to send when you're resigning, and just a conversation about how this is all going to work and what the prospects of gaining that severance for you is, how much your severance might be, etc. So yeah, good news there. So just looking back at Bill says we're in Ontario, and Bill is the one with the spouse that was a caregiver. Ontario is going to have similar leaves to Alberta, but you can reach out to our intake and they'll direct you to someone in Ontario. And there's a message here that seems a little bit like it's just not connected to anything. Karen on Facebook saying structured termination, making your work life miserable until you quit. I've never heard it called a structured termination. We call that constructive dismissal. And constructive dismissal can be based on a toxic workplace and entitles you to severance. I'm not sure if there was supposed to be more to that, but okay, there's a couple here from YouTube. So it's like the same person. Oh, okay. So this is the same person that had the job switch to 80 kilometers away. Says, I left a good stable job for this, and now I'm likely out of a job altogether. Is there anything I can do? Well, I mean, that would factor into your severance. If you were enticed to leave a job, and then, they've changed the terms, that could be something that might factor into how much severance you can get. I'm not sure how long you've so, okay, sorry. I thought when you said it was supposed to start a new position this month, I thought that it was like more of a transfer within an employer that you were already employed with. So what you're saying is that you were at a different job, got offered something, and then they changed it. So severance may not be a thing, but you may be able to sue for kind of a breach of contract. And ultimately, I guess it would be sort of the same damages as severance. Um, yeah, again, I would say reach out to us so that we can review the terms of the offer and what exactly has happened. I doubt that we can make them give you the job, but you may be entitled to some damages, and we can help you with that. Okay. Um, Question from Peter on YouTube. I'm returning from medical leave, but my employer insists I provide detailed medical records instead of a simple note from my doctor. What are my privacy rights and what medical information am I legally required to share? So, definitely not detailed medical records, but I'm not sure what exactly you mean by that. What the employer is entitled to on your return is enough information to determine if you require any accommodations due to the medical situation. So often what they do is they have a form that they have your doctor fill out that basically it'll say if you have any accommodations, if you have any restrictions. So restrictions on hours of work, restriction on days of work, restrictions on physical things, sitting, standing, lifting, reaching, etc. The reason the employer is entitled to ask for that is because they have a duty to accommodate any restrictions that you have on your return. So they need to know what they are. So a lot of times they will ask you to get a form filled out by your doctor that's going to say, what these potential restrictions are. If you don't have any, the doctor's just going to say, cleared to return, no restrictions. But I'm not sure what you mean by medical records. Like, I don't believe they have any entitlement to your medical records. They have entitlement to some medical information insofar as it is required for them to fulfill their duty to accommodate. But they can't ask you for your kind of medical charts from your doctor or anything like that. Yeah, they are allowed to ask you for enough medical information so that they know if they need to accommodate you. And really, that's it. You don't even have to tell them what your diagnosis is. It just has to be enough that they can determine what your accommodation requirements are. So hopefully that helps. When you're returning from a medical leave, a simple note from your doctor often just says you're cleared to return. If you don't have any restrictions, that is enough in your doctor's note. So I guess I'm just not sure exactly what they're asking you for. But I guess at the end of the day, what they are entitled to is the information to know whether or not you have any accommodations that they have to deal with. So hopefully that answers your question. That's all. Is there any more? Maybe there's one about this. Oh, there are more. I just have to scroll up. Okay, so there's another one from YouTube. If your employment contract has language in it that says you're only allowed to receive ESA minimums, how legal is that? Can you negotiate a change? At the time that you're signing the employment contract, you can always negotiate those terms if you have that kind of leverage, if they really want you to come there, and you can negotiate those terms, of course. Once you've signed the employment contract, if how legal is allowed to receive ESA minimums, employers and employees can agree on different termination entitlements other than common law entitlements. So you can agree that you are only going to get the minimum under the Employment Standards Act or Code, depending on where you are. But that language has to be quite specific. It has to be very non-ambiguous, and it has to be not illegal. There are a lot of issues that can come up with those termination clauses, and we deal with those all the time. There's a lot of files that I have where we're arguing that a termination clause like that is not enforceable, and there's a lot of ways that it can't be enforceable. So I would get it reviewed. I would get it looked at to see, by one of our lawyers to see if that clause is actually enforceable and restricts you to employment standards minimums. How we negotiate for more than employment standards minimums in those cases is we argue the clause isn't enforceable. So hopefully that answers your question, but I would get it looked at to see what a lawyer in your jurisdiction thinks about whether a court would actually enforce it. A lot of them are not enforceable. I have another question from Facebook from Lena. I came back from medical leave and my employer gave half of my responsibilities to another employee and they're not giving them back to me. Been here 8 years. What are my next steps? So under employment standards in Alberta, you need to be returned to the same or similar position after a medical leave if it's shorter than 16 weeks. Also, that could be a human rights violation because if your job has been changed due to an enumerated ground. So if you have a disability that caused you to go on medical leave, so not just a medical leave for something that wouldn't be considered a disability, but anything kind of with a diagnosis is considered a disability. Next steps, I would say, is talk to somebody, one of our lawyers, and we can see what we can do with that. You could be in a constructive dismissal situation where we could get you some severance. You could be in a human rights violation situation where you could get some damages for that. So I think you need to have a conversation with one of our lawyers and see what your entitlements are and what you should do. Next steps, that's what I would recommend. I mean, you could go talk to the employer about it first, obviously, and say that you are supposed to get your same role back. And if that doesn't work, reach out. So another question from Sandy, that's from YouTube. If a letter of expectation says, should we become aware of further incidents, you will be subject to disciplinary measures. Is it evidently non-disciplinary? No discipline mentioned elsewhere. It sounds disciplinary to me. I would need to probably look at the entire document. Not really sure what difference it makes if it's disciplinary or non-disciplinary. I think the real concern is what is going on here with this letter, because if you have this letter and they're saying if there's anything else you're going to be subject to disciplinary measures, then they're setting up for a termination, for a just cause termination, which wouldn't entitle you to severance. So you need to be careful with the letter on its own, and then I don't know why it matters whether it's non-disciplinary or disciplinary. The discipline, and you're saying no discipline mentioned anywhere. In my view, the discipline is the letter itself. A form of discipline is a written warning, right? So that sounds like a warning to me. So the next comment from the same person, it makes a difference if it gets used later as a disciplinary letter. I mean, I don't know. I don't think it matters what you call it. It's a letter of expectation. It can be something that's set up as, it's warning you that if this is going to happen, you're going to be subject to discipline. So I think it's disciplinary because the letter itself is the discipline. It's a written warning. I would consider it, if you got fired after that, I would say you had prior discipline because you had this written warning. But I mean, the whether it meets the definition of a disciplinary letter or not, I don't know that matters at the end of the day in the eyes of the law anyway. Maybe you're looking at some policy or something, but I mean, if somebody's terminated for a cause and they have a letter that says, if we become aware of X, we're going to terminate, that factors into whether or not the employer can actually terminate for cause. So, I wouldn't get too hung up on whether or not it is a disciplinary letter, but in my mind, a written warning letter is considered discipline. Hopefully that answers your question. Yeah. So it's 1:30, so I guess doesn't look like I have any other questions. I think we've got through everything, and I hope we've answered everybody's questions. Tried my best. It's sometimes hard on very, very tiny little bits of information, but hopefully, if your questions haven't been answered, or if I've kind of recommended come talk to us, think about doing that, because it is a good idea to have someone review all the circumstances, and you can reach out to us on our website and through our intake team. My dogs are trying to make an appearance in the background there. Yeah, so there's other live streams coming up, employment law Q&A, excuse me, tomorrow 1 p.m. Eastern time, and that's with Lior. So that's a good one to attend if you have further questions. So hope to see you again next time I'm on. Thanks, everyone.